Members, we formed a quorum and it's also the appointed time. May I call the meeting to order. Following our House rules, we have to elect a chairman for the Bills Committee. Any nominations, please? Mr. Wong Ting Kong, I nominate Mr. Chen Kam-lam. Do you agree? Do you accept? Any seconder? I do. All right, I do accept. So we need somebody to preside over the election of the chairman because there may be other nominations. Mr. Jeffrey Lam, your turn to chair the meeting. Members, any other nominations, please? No? Then Mr. Chen Kam-lam, elected chairman. Please come back to the stage again. Members, do we need to elect a deputy chairman? So, Ms. Emily Lau has the say, has the final say. I wish I had. All right, if there is no need to elect a deputy chairman, please invite the administration to join us. Now, we will go into recess quite soon. If we start a briefing of the bill, then 2 months afterwards, members cannot remember anything about the bill. Then why don't we adjourn now? Yes, I would like to discuss with members schedule of meetings. While the administration is coming in, now please, quiet please. Although we are in holiday mood, let's discuss how we're going to proceed. We first invite the administration to give us a briefing of the bill, and we can also exchange views of the administration. And subject to members' agreement, we may invite deputations after the summer recess. So this meeting can be brief. All right, it's up to members. Because we have spent many years on this bill already. Let us welcome Ms. Patricia So, PAS for Commerce and Economic Development. Mr. David Wong, Deputy Secretary for Commerce and Economic Development. Ms. Michelle Zhong, Assistant Director of Intellectual Property. Mr. Henry Chan, Acting Senior Government Counsel, and Mr. Michael Lam, Senior Assistant Law Draftsman. Mr. Wong, Deputy Secretary, can you walk us through the paper, please? Mr. Wong. Thank you, Chairman. Allow me to spend some time to brief members on the bill. Our copyright regime has to be updated from time to time with social and technological developments so that we can catch up with latest developments globally. So the government has been thinking since 2006 how we can update our copyright regime. In 2011, a bill was introduced to Council to introduce the concept of communication right in safe harbor to deal with new changes. Back then, the question of parody was not part of the bill, but there was great concern. So although the bill got the support of the Bills Committee after its deliberation, it did not receive its second reading, or it did not resume its second reading, and it lapsed with the expiry of the last term. And last year, In July 2013 to November 2013, we consulted the public on the question of parody again, and then we gave a briefing to the CI panel of LegCo in March last year and December last year and March this year. Many members wanted us to introduce a bill to the Council as soon as possible. So as far as the Copyright Amendment Bill 2014 is concerned, we have incorporated the previous bill already examined by members plus new proposals to deal with the question of parody. There are 5 main areas. First, communication rights. Second, criminal liability. 3, copyright exemptions. 4, safe harbor. And 5, civil liability. First, on communication right. At present, the Copyright Ordinance gives copyright owners certain exclusive rights, including the right to make a copyright available to the public on the Internet, to broadcast a work or to include a work in a cable program service. With advances in technology, new modes of electronic transmission, such as streaming, have been emerging, and the current scope of protection may not be adequate. So we propose to introduce a new exclusive right for copyright owner to communicate their works to the public through any mode of electronic transmission. This will assist copyright owner to develop their works in places like Australia, EU, Singapore, New Zealand, and Canada have introduced these statutory communication rights since 2012. And then the second part is about criminal liability. Because of the communication right, we propose criminal liability, and this is the same as distribution of infringing copies. Anyone who without authorization distributes infringing copies, then if the purpose is for profit or reward, and to such an extent to affect prejudicially the copyright owners, then you are criminally liable. To allay the concern of the public as to whether this would affect freedom of expression and certainty of the law, we already proposed in the last bill to clarify what amounts to such an extent as to affect prejudicially the copyright owners. The BC last time allowed us to clarify whether the infringing acts have caused more than trivial economic prejudice to the copyright owners, and to introduce a non-exhaustive list of reference factors to guide the court in determining the magnitude of economic prejudice. Subsequent to our public consultation on parody, we propose to clarify further in this bill what is meant by such an extent as to affect prejudicially the copyright owners. We will no longer use the phrase more than trivial economic prejudice. Rather, we will put it in the law that the court, when considering criminal liability, should consider the case as a whole and to see whether the infringing work would be a substitute for the original copyright. And the third area is exemptions. There are over 60 provisions used under special cases for research, personal, private study, education, criticism, review, and reporting current events. And under such circumstances, there can be fair use of copyright works without any criminal or civil liability. With the introduction of communication rights, in order to strike a balance, between copyright protection and reasonable use of copyright works, we propose to introduce new copyright exemptions. First, for the purpose of parody and satire, caricature, and pastiche. Second, for commenting on current events. And 3, for quotation. Now, if the use is fair, then there will not be any criminal liability. And in addition to this, we have also got other exemptions which are reasonably needed. For instance, for a purpose of teaching, for distance learning, for libraries, museums, and archive operation, for temporary reproduction of copyright works of OSPs, and for media shifting of sound recording. All these will be included in the bill. We believe that with the exemptions, we should be able to cover all the normal activities on Internet for protection of freedom of expression. And we've also got a statutory safe harbor regime if some conditions are satisfied. For instance, when there is infringing acts on a certain platform, and if an act is taken to stop that, then the person would only have to be limitedly liable. This is to ensure that people can address accusations of infringement. There are different safeguards to respond to views of stakeholders, to avoid abuse, and to protect the privacy of users. And then civil liability, and that is about extra loss or damage compensation. For established cases of civil infringement, we will add new statutory factors for the court to consider when it considers awards or compensation in order to be fair. Since the end of last century, because of the development of Internet, places like the U.S., Australia, Canada, and Singapore have amended the copyright legislation to respond to rapid development of technology. Our copyright regime has to be amended in a timely manner in order to keep abreast with global developments. In drafting the bill, we have discussed with stakeholders, including copyright owners, users, netizens, and OSPs. We liaise with them very closely to listen to their views to ensure that our bill can address the concerns of different parties and can strike a reasonable balance among the interests of different parties, and also to honor our obligations under various treaties. So we will step up enforcement and crack down on infringing activities. We've added new exceptions to take care of normal activities on the Internet to safeguard the freedom of expression of the general public. We look forward to a cooperation from members so the bill can be passed as soon as possible. Thank you.
2 members have raised their hands. Ms. Claudia Mo and Mr. Wong Yok Man. 5 minutes for each member. Ms. Mo. First of all, I have to praise the Deputy Secretary, Mr. David Wong. When I went to the forums organized by netizens on this so-called Article 23 on the Internet, I always saw him. For the first and second time, I didn't notice you, but from the third time onward, I did notice that you were there. You listened to the concerns of netizens, especially young netizens. Once a complaint is lodged by the copyright owner, the OSP has a duty to delete the content. And then the platform will only be asked to show the limited liabilities. If I launch a complaint and then the content is deleted, wouldn't that affect the freedom of expression? That's the question that left a very deep impression on me. You said parody, caricature, pastiche, they will all be excluded. And then a commentary of news or comment on new current events is a new factor. I know you have give some concessions, offer some concessions, but it's not enough. You see this? Didn't they ask you to take a photo? This is to be used if you want to pretend that you are a clown. So everyone has to make themselves funny, satirical, and then you're safe. You're safe is for fun. What if I don't want to get some fun? What about UGC? User-generated content. And then it's an open-ended exception. Don't be so rigid. If it's not parody, not satire, not caricature, not pastiche, or not comment on current events, or not teaching, then you have a problem. If you want to provide exceptions, why don't you be more open-minded and provide some open-ended exceptions? Mr. Wang, first of all, on the operation, this is about the operation of a safe harbor, and also it's also about exceptions. We have made reference to advanced countries in how they deal with infringement on the internet. The spirit of the arrangement is that the platform is neutral. It allows many users to upload contents, different contents. There's no need for the platform owner to screen messages before the messages are disseminated. But the downside of doing this is that if there's an infringing work uploaded, then the damage can be multiplied. For example, if there's a major Hollywood movie uploaded to the internet, say Transformer, if you use a browser search engine, you can find many entries. Well, you are repeating what we were told in the past. Of course, we know that if it's a Hollywood mega movie, you are affecting people's economic benefits. But we're talking about user-generated content or secondary work. You should not just say that you copy advanced countries. We have to be very careful about the fifth estate. For example, the right of expression and news freedom. If we can take care of the concerns that there will be unreasonable accusations, thereby affecting freedom of expression, we do have a mechanism to protect such expression. If someone submits a notice to the OSP, the content of the notice must be true and correct, and only the copyright owner can submit the notice. If the content in the notice is not correct, there are civil and criminal liabilities. So it's not something you can do without any consequence. And then the OSP would issue will be informed. The OSP will inform the uploader, and then the uploader can serve a counter notice. Mr. Wang Yoman, in my past life, in the past few decades, I have been a content provider. Of course, I'm concerned about copyright. I was a victim of copyright infringement. That is in respect of my DVDs. But I'm also concerned about freedom of expression. Now you want to protect intellectual property. But if you affect freedom of expression, then even though I'm an author or copyright owner, I'm going to oppose to it. You presented a bill in 2011 to this council. It was decided that the second reading would be resumed in 2012, and then it just happened that there was a filibuster on the replacement arrangement of legislative members who resigned. So there was a 2.5 months of filibuster, and the copyright bill was withdrawn. You're not going to say this, therefore I have to. During the filibuster, I tell Mr. Grasso that it was a waste of time. Please retract it. So we serve a number of purposes. With one filibuster, we stop the creation of the new 4+12 government structure. If you were able to get the bill to be read the second and third time, it would have been passed because even Ronnie Tong supported the bill. Well, the devil is in the details. For these exceptions, we have to look at them in detail. There are three options to exempt criminal liabilities. All of them have shortcomings. So when we come to the relevant issues, we'll ask for a government paper, and then we would be offering more details. I'm happy that you are not going to use this term, more than trivial economic loss, economic loss. And also for user-generated content, as long as there's no substantive economic prejudice or the substitution of the original copyrights, then the exemption will be applied. This is supported, but we need to look at the contents. Paragraph 19. The government has some reservation about dealing with this UGC. It said there is a vague concept. There's no accepted definition at the international level, and it seems to evolve with technology. Well, there are correct parts and there are incorrect parts in this statement. Well, universal suffrage has a universal or international standard, but you don't want to copy it. Here, you want to have something widely accepted in the international community. This is really laughable. Why do you have to insist on having a definition which is accepted in the international level in respect of UGC? When we proceed to cross by cross, I will have to speak on this. The introduction of UGC, user-generated content, has some merits. The concept may evolve with technology, but it would make sure that the netizen will enjoy freedom of expression, and that the definition would keep pace with the development of technology. Some if it's not about comments on news events, they will not be covered. When we proceed to that particular issue, I'll offer more views. Whereas Mr. Wong has said, we'll proceed to a more detailed discussion when we do the cross by cross. Mr. Chen Chi-chin, I have to first of all praise the administration that it has made great improvement over what they did back in the 2011 exercise. The Deputy Secretary and other officials were very eager to listen to people's comments, and even the facial expression, according to some stakeholders, was much better this time. In the past, copyright means making a copy or broadcast. Now it's about communication. The first time I saw the word communication, I was scared. although the administration has said that this is technology neutral, some netizens joke that it will cover telepathy because it's communication. But now you're talking about communication in electronic means. Maybe the administration can explain further what is meant by communication. It seems to be very wide this time, and it covers almost everything. But there's no clear line drawn, or is it a deliberate move not to draw a clear line? Apart from substitution of the original word, we will have to look at the purpose of communication. Is it commercial, or how much of the original work has been used, the scope of communication, the number of people reached. All these are not defined here. And also streaming is covered. What about share links? If a link is shared, I have no control over what's covered by that link. Today, the link may be okay, but tomorrow the link may be about some copyright works. So would the liability be exempted? Can we get some explanation? Mr. Wong, thank you for your questions. We want to protect copyright, so no copies are allowed, or no distribution of infringed copies. There are already a wealth of case law that if pirated copies are distributed over the internet or electronic, the king of crooks was one of the cases. Yes, it was about distributing the electronically infringement copies. But you may have a copy in each case. But why do we have to come up with this idea of a communication right? Back in 1996, there was an agreement on internet services, and it was considered that the concept of a communication right should be introduced. And after the international treaty became in force, many countries introduced this concept of communication rights in their law, and Hong Kong should follow suit to honor our international obligations. So it's a linked equivalent to communication. Well, we did consider this in drafting the bill, because some people, some netizens may not know what is behind that link. So in the past bill and in this bill, we'll make it very clear that electronic transmission doesn't cover the provision of a link if the one providing the link doesn't know what is behind, or what is the link about. It's just like the current legal definition of distributing infringement copies to the public. We want to be technology neutral. We want to deal with matters or problems on the internet, but we will not cover telepathy.
But some are worried that the scope will be too wide, and have you considered how to allay their concern? Well, there are different exemption provisions and also provisions to clarify the criminal liability. I believe this will be able to address their concerns. Mr. Frankie, Mr. Yu Siwing, I understand that our legislation cannot cover internet. Take advertisements of the tourism industry as example. If the advertisement is against local legislation, the trade cannot regulate, cannot monitor this. If overseas or mainland people have electronically transmit our creation breaching the copyright ordinance, what should we do? If a copyright owner has also violated copyright provisions of the mainland or other countries, how do we tackle that? Thank you. Our copyright legislation can only has jurisdiction in Hong Kong. So if the infringing act takes place overseas, it is not something our law can tackle. But if the act is related to Hong Kong, then we have the opportunity to deal with it. For instance, infringing server distributing infringing copies of movie, and if the uploading has taken place in Hong Kong, there's the possibility of invoking local laws to tackle that. The Customs and Excise has recently dealt with a case because somebody in Hong Kong has used a copyright-protected content and uploaded to overseas servers. Because the uploading act took place in Hong Kong, the Customs and Excise could take enforcement action, and that's why we have to honor our obligations under world treaties, because if all jurisdictions adopt the same standards in dealing with infringing acts, then we can cooperate and tackle infringing act through the internet, which straddles countries. That means we can use our legislation to deal with infringing acts in Hong Kong. Take the set-top box as an example. Now, if it is bought in Hong Kong and used in Hong Kong, is that against the law? So, how do you define whether an act is caught? Well, whenever we have our jurisdiction to tackle, we will tackle. But for set-top boxes, well, different boxes have different technology, so we have to consider individual cases. If the infringing act has taken place in Hong Kong, then we can invoke Hong Kong law. This is a basic principle. If it is overseas, well, when our customs have received complaints that an infringing act has taken place overseas, and if the act is also an offense there, then we can cooperate with overseas enforcement agencies. For instance, in a mega upload case a few years ago, it was a transboundary infringing act, and Hong Kong, US, and New Zealand customs cooperated to take enforcement action. If there is a certain organization on the mainland found to have to engage in infringing act, what can we do if the authorities there do not take action? Well, all jurisdictions have their own judicial system. The copyright owner, if his interest is undermined, he can do what he is allowed to do within that legal regime. Can we ask the authorities of these jurisdictions to assist? Well, when the Customs and Excise receive inquiries, we'll try to help as far as possible. For instance, how many countries have signed such agreements with us? Do you have such information? Well, we talk about our international obligations. We are a member of the World Intellectual Property Organization's Copyright Treaty. I understand that all World Trade Organization, WTO members should be parties to the treaty. Mr. Charles Mock, when we were consulted on this bill, I was still an OSP. That was 10 years ago, and yet the bill is not yet passed. So I do agree that our legislation far lags behind other jurisdictions. So even though members may say that the law is far from perfect, we have to accept the situation. Now, Mr. Wong, members have commended you this afternoon. I joined them. In the past couple of years, I have organized a few seminars or conferences of such a matter, and I found you on all these occasions. But you shouldn't be happy too early. Yes, you shook your head, so you do understand. The last bill was introduced in 2012 or 2011, all right, 2011, but it could not be passed in 2012. I think our focus of the bill will be on parity, and for other provisions, the last bills committee covered most of the aspects, but of course there's a change in membership, so some of the issues may be revived. I think all we want to do is to strike a balance. The last bill focused on combating infringing acts. Of course, that should be done. Because the bill was subsequently not passed, there were issues not yet resolved. Back then, I protested outside the complex at places where protests are no longer allowed. I said that there must be protection of freedom of expression and also the right to make parodies. And netizens seem to understand the rationale behind the bill and that exemptions are provided. So your exceptions represent a proper way forward. The question is whether the exceptions provided are sufficient, or can we just take them first, and can there be any adjustment in the future? The copyright bill, the Bills Committee will focus on these issues, but I'm afraid that it is no easy task because the technical clauses are very technical. If we wait until the clause-by-clause scrutiny stage, I'm afraid we might be going round and round in circles. So I think we can all expect deputations expect meeting of deputations, and then we have 2 months of summer recess, and the next meeting will probably in September. At the start of next meeting, can the administration brief us again? Because given the thickness of the bill, not many members have read it through. So in September, can you give us in details the exceptions you are talking about? Of course, they can be found in the paper, but can you give us another presentation? For instance, netizens would like to have UGC, and you say that it is not acceptable. Why? Can you tell us the reason why, and also the global trend? Please give us a detailed explanation so that when we return from the summer recess, we can all listen to your presentation once again before we meet deputations. Because if we invite deputations to meet us, they throw out lots of concepts, and yet if members have not done the revision, that may not be most effective. So I don't really have a question to ask. I am just making suggestions for the chairman and the administration. Yes, I think we will have time. For members to be briefed on the detailed provisions. Mr. Sin Chung Kai. Chairman, thank you. The summer recess is just at the corner, and I will also discuss whether we are going to meet deputations. I believe we have to, and it will be sometime in mid-September, and we need to do the preparation work on our electrical website. And I think the most controversial part of the bill is exception for parodies and whether it is sufficient. As for other CSAs, I think they have been thoroughly addressed at the last term of the last term. Perhaps we should consider carving up the bill into several parts so that we can have in-depth discussion of each part. And the administration should be more flexible in our meetings with deputations. What do I mean by being flexible? Now, there should be one meeting with deputations, and by the time we go through the bill clause by clause, I'm sure there are provisions less controversial than others. But when we come to controversial provisions, then we may have to meet deputations for the second time. The thinking is just like the idea of Mr. Charles Mock. Yes, as soon as we start, we should invite deputations to come and give us their views. And after the administration has responded, we can have one more hearing on more controversial subjects. I think the scope has narrowed down in the new bill. Still, it won't harm to introduce, to explain the bill to the community better. Mr. Wong, your hard work and also your attitude have received the commendation of members. I hope you can keep up with your good work, and let's hope that we can narrow down our differences and pass the bill. We may not be able to make everybody happy, but we should work hard together. I suggest that we convene our public meeting with the public earlier, and then after the first meeting we can decide whether we want to meet deputations for the second time. I think members are making the same requests. They would want the administration to tell us the details of the bill when the opportunity arises. Mr. Kenneth Kwok, I know we are not going into a clause-by-clause scrutiny yet, but can you tell us about a 8C substitution for the worker, because this is a relatively new concept. So I'd like to know which jurisdiction do you mirror this after, and can you give us case laws so that this new concept, substitution for the worker, can be better understood by us. And 241. Criticism and review. Section 241, subsection 1 looks rather complicated, and there are a number of issues to be involved. It says that the court can consider the following factors, such as C, the amount and substantiality of the portion. Can the administration explain this to us? And if there are case laws, please show them to us.
Thank you for your questions. This is really about the prejudice, the term we use. But it's used by other jurisdictions such as the UK. but they do not elaborate in their statute law what is meant by prejudice. In the last bill, because of the concerns expressed by netizens, we already set out the factors that would help us decide what is or is not a prejudice. In the last bill, there were 4 or 5 factors. When the bill was scrutinized last time, some members asked whether the factors we set out were properly drafted. And we now use this term substitution. Last time, members agreed that that would be a better approach. And then we were asked to introduce these committee stage amendments, but of course the bill lapsed. And then in subsequent consultation, we talked to different stakeholders. Although the views of users and copyright owners can differ a lot, but in terms of criminal threshold, they think that whether it would tantamount to a substitution of the original works, it was agreed that the courts should be referred to in deciding whether there is a criminal liability. So we believe that the current formulation in the bill is better. There are quite a few cases that when the court considers whether there is infringement or the extent, they would look at whether the infringement act resulted in a substitution. As for whether it's a fair dealing and the 4 factors, I would say that under the existing ordinance, we have already got other provisions on fair dealing. The factors are nothing new. Fair use is practiced in the U.S. and is also in their statute law. We can look at the courts of the U.S. and other common law jurisdictions when they, and then we can see how they consider the fair use and the factors in deciding whether there is an infringement. For example, under 8CB, you talk about substitution of the works. And then you also state that the courts can have regard to all other factors. So mainly you will consider substitution, but other factors will also be considered. I think we have to consider whether this is the right approach, because we see some ambiguity here. We understand that the most important factor is whether there is a substitution of the original works. But I'm a bit concerned about 8CA. Mr. Wong, please note the concern of Mr. Kwok. Other members? Okay, nothing? I don't think we are saying that we have no questions on this bill, but when we proceed to cross by cross, I believe we can all offer further comments. Let me now discuss with members the organization of public hearings. It's been suggested that we should have not just 1 public hearing, but 2 or 3 public hearings after the summer recess. A member has proposed whether this should take place in mid-September. We are going to send 2 delegations in mid-September, one to North Europe, Nordic countries, another to Singapore. And some of our members will be joining those delegations. So I believe early October will be more appropriate. I'll work out the schedule with the secretary. And we are going to extend our invitations through our very well-established networks to invite deputations. The Secretary will inform you of the list of invitees. If you are aware of any particular organization or individuals who or which may be interested, please let the Secretary know. I have no objection to arranging public hearings in early October. In the past, we would organize a public hearing by reserving 2 slots, and then we divide the time among the stakeholders. I don't think this is the good approach. I think we should give every deputation 5 minutes, and then we decide the meeting time in accordance with the number of delegations. Well, let's see how many deputations want to join us. Then we can have 2 or 3 sessions, or if there are many of them, we can have a whole day meeting. Well, of course, I want to make sure that they would each get 5 minutes. Yes. Well, we must hear their views on this particular bill. It's not just an opportunity for them to say if they are supportive or not. I would just want to suggest that we should have a long and detailed introduction, not what we had a moment ago. There should be a PowerPoint to allow us to retain more of the contents, and then the public hearing or hearings will be effective. Because if the deputations mention some new concepts which members hear only for the first time, then we are less efficient. Okay, we'll consider this suggestion. Other members? Any suggestions? No? Okay, the meeting's adjourned now. I'll work with the Secretary to arrange things, and then we are going to have a meeting before we have public hearings, and the government is invited to brief us in a more detailed manner the 5 major parts in the bill. And the members will warm up, and they may have more questions for you. This is just the beginning. And I believe efficiency will be higher as a result of this arrangement. The members have been praising you. I hope you would have proved yourself to be deserving it.